What's your name, sir? What's your name, sir?
Anthony Clout.
We're ready on the clock matter, Your Honor.
Okay. Is that with a K?
Number 29, Your Honor. Klauck.
25 CR 5887, People versus Clout.
Kevin Warden for the people.
Good morning, Your Honor. Robert Levine on behalf of Mr. Klauck, who appears to my right in custody.
Okay, good morning.
And thank you, Your Honor. We've been working on disposition in this matter. Mr. Klauck informs me today that he would like to set the matter for motions and jury trial. So we would ask the matter be set for motions and jury trial.
All right, you want to enter a not guilty plea? Do you correct? And
At this time, Your Honor, I would like to relieve Mr. Robert Levine as my counsel, and I would like to enter a plea of not guilty, Your Honor.
are you asking to go pro se, or what are you asking for?
I am firing Robert Levine for violation of Title 18 United States Code 241 under conspiracy against one's rights. I have also have some motions in my pocket in regards to complete dismissal of all charges, Your Honor.
Are you asking to proceed pro se? Are you asking the court to appoint alternate counsel? Let's start one at a time.
Alternate counsel, Your Honor.
Mr. Levine, are you ADC or are you private?
Your Honor, I am ADC and I work for Mr. Reich, who was appointed on the case as well.
Okay, so Mr. Reich is the appointed counsel.
Correct.
Right. Okay, and you're with his office. Okay, what's the, Mr. Klauck, in order for the court to appoint counsel other than the one that's already appointed, I have to make a finding that there's a legal or ethical conflict. Are you asserting a legal or ethical conflict?
Yes, ma'am, Your Honor, for violation of my constitutional rights of due process, and not only that, but also committing a conspiracy against me under Title 18 United States Code 241, Your Honor.
Okay, here's what I'm going to do because I have a pretty long big docket. I'm just going to pass your matter. We'll call your matter at the end of the docket, sir. You can provide whatever information you want, but I need to make that initial determination before I can proceed in either direction, and then you'll have some decisions to make. Okay, so we'll recall your case at the end of docket.
Yes, ma'am, Your Honor.
Okay.
Your Honor, I straight fired this dude multiple times. He is not my attorney.
This is our motion to adjourn.
Mr. Klauck, we're going to call your case and then we can have a conversation, okay? This is 8 on the docket, 25 CR 5887, People versus Anthony Klauck.
Kevin Warden for the people.
Rob Levine on behalf of Mr. Klauck, who appears to my right in custody.
Okay. Good morning, Mr. Klauck. First, I wanted to say I told you on Monday that we'd hear you that afternoon. I was unable to do so because counsel were not available. So that's why we had to reset you for today. Any questions on that?
No, ma'am.
Okay. On Monday, I had set the matter over because, as I understood from Mr. Klauck, he wanted alternate counsel appointed. I indicated that I need to hear some more information on that. And then since that time, there's a pending motion filed by counsel indicating that they are requesting to withdraw. Is that accurate?
Yes, Your Honor.
Okay. The motion indicates that the basis for the withdrawal is that Mr. Klauck wanted to proceed pro se, which is not what I understood on Monday. Is something changed?
Your Honor, that's based on my meeting with Mr. Klauck yesterday. That's the representation he made to me.
Okay. Mr. Klauck, let me ask you, again, that's not what I understood you to be saying on Monday. Are you asking to proceed pro se, or are you asking the court appoint another attorney to represent you?
I would like the court to appoint another attorney based upon my Miranda rights, Your Honor, due to Mr. Robert Levine violating Title 18 United States Code 241, conspiracy against one's rights and violation of due process under the Fifth Amendment of the United States Constitution and Article 2, Section 25 of the Colorado Constitution as well, Your Honor.
Okay. So a couple things there. I'm just going to advise you generally. You have court-appointed counsel. You are entitled to court-appointed counsel when you are determined to be indigent and you're in custody, so you're determined to be indigent. The court appoints counsel. In your circumstance, there was a conflict with the public defender's office that was determined earlier on. Based on that conflict, you were appointed, I believe, technically it was the law office of Scott Reich was appointed, but Mr. Levine has been representing you, is that correct?
Yes, ma'am, Your Honor.
Okay. In order for the court to find a similar conflict or another conflict that would warrant appointment of yet another counsel, I can only do that if I find that there is a legal or ethical conflict. Does that make sense?
I would think that there would be a legal conflict based upon violation of due process, Your Honor.
Okay. So what I want to say this is in order to make that determination, I'm going to have to ask you for some more information on what you assert the legal conflict is. I want to advise you ahead of time that any conflict allegations that you make, to the extent that they may touch on privileged information between you and your counsel, that privilege would be waived as it relates to the conflicts that you assert. Same with confidentiality, it would be waived as to any conflicts you assert. Your attorney would be able, and indeed I would require that they respond to any allegations. Do you understand that you're waiving any privilege or confidentiality?
Yes, ma'am, Your Honor.
Okay. Help me understand, what is you mentioned the conflict has to do with Miranda. What is that?
In regards to Miranda, I actually have written motions that I would like to submit to the court and also the people as well, Your Honor. Is that possible?
I can't do it directly. You'd have to file it with the clerk, so you can mail it.
Well, once again, Your Honor, I am in custody and I cannot file it with a clerk, and all I can do is written motions, Your Honor.
Yes, written motions are often filed by people in custody. You can do that through the jail in the mail. But if you'd like to make a record, and if that is in just reading from the motion, I'm happy to hear.
Yes, ma'am. I'd like to read the motion if that's possible, Your Honor. Motion to dismiss date 12/19/2025, defendant Anthony D. Clark, who is present, Your Honor. Motion to dismiss charges in the Denver District Court Case 25095887. And the discovery, it can be seen.
Sorry, Mr. Clark, I'm going to stop you there. I'm not hearing a motion to dismiss charges. If you have motions relating to the conflict with your counsel.
And in
That's-
regards to my counsel, Your Honor, I told him about the mistreatment I was going through in the county jail, and he still proceeded to want me to remain in custody. He still proceeded to try to cover up the fact that my rights were being violated in the county jail, Your Honor. And I gave him plenty of documentation and even have a grievance form that I even submitted to the county jail of the jail violating the False Records Act, False Claims Act as well, with multiple officers violating their oath of office that they signed with the affidavit to the state of Colorado in regards to their oath of office to the United States Constitution, Colorado Constitution, uphold and enforce the laws of the state of Colorado, Your Honor.
Okay, is that a separate issue from Miranda?
In regards to Miranda, it's regards to all the officers involved. I was never read my Miranda rights, Your Honor. And this is also found in the discovery as well, which means every officer involved in my arrest violated due process under the Fifth Amendment of the United States Constitution and Article 2, Section 25 of the Colorado Constitution. And also, with that being said, Your Honor, Title 18, United States Code 1918 is being violated by the oath of officers who are testifying against me or going to testify against me in the upcoming trial, Your Honor. And based upon my knowledge under Title 18, United States Code 1918, even the prosecutors themselves can confirm that that is a felony And not only that, but also violating Title 18 United States Code 241, conspiracy against my rights, and Title 18 United States Code 242, deprivation of rights under the color of law, which is also felonies, Your Honor. And with Mr. Robert Levine violating due process and also committing felonies of conspiracy against my rights after he was informed, Your Honor, once again, confidentiality has been waived, as we agreed. And I did speak to my attorney about my rights being violated in the Denver Detention Center, downtown Denver Detention Center. And this seems to have not been reported to anybody. And I've been trying to report this to the Federal Bureau of Investigations and also to the Department of Justice Civil Rights Division as well.
Okay, so as to that issue, I just want to make sure I'm understanding you, that you've had some difficulties in the jail, you believe your rights are violated in the jail, and what are you asserting Mr. Klauck is doing or not doing that creates the conflict with respect to that? Or I'm sorry, that Mr. Levine is doing or not doing?
Not informing the district attorney, prosecutor of the matters in regards to crimes being committed against me and me being discriminated in the Denver downtown detention center, of my First Amendment under protection under religion, the Colorado Constitution, Article 2, Section 4, freedom of my religion, also violating the Civil Rights Act of 1967, Your Honor, discriminated against me under religion. Also, the state law of the Colorado Anti-Discrimination Act of 2013, also discrimination under religion, and not to mention violation of the federal law of the Religious Freedom Restoration Act of 1993. And I would like the court to know that as a Messianic Jew, I am kosher and do both Old and New Testament and the Holy Bible. And with that being said, I am also protected under the Anti-Semitism Act of 2023, Your Honor.
Is there anything further?
Other than that, my attorney clearly seen in the discovery that violation of due process, in addition to him being aware of my rights being violated in jail, also in the discovery that was submitted, the perjury was done, and the persecution of the state of Colorado still wants to proceed in this matter, which means they would be violating due process as well, which means they would be violating their oath of office to the United States Constitution, based upon Matthew, who is one of the names in the mandatory protection order in my case in the discovery, committed perjury and with two different names of Cecilia and Sabrina, submitting false evidence through Sarah Michaels at University Health, committing perjury and also violating the federal law of the False Claims Act. And the matter that he still wants to pursue the case and not defend me and bring this to the prosecution's attention, this in itself makes me feel like this is a conflict of interest based upon due process, that not only is Robert Levine also violating due process, but also the state of Colorado under the prosecution as well, Your Honor.
Mr. Levine, did you want to respond to anything?
Briefly, I think what he is actually referring to is the SBI forms in the case. That's something we discussed. The SBI forms contain different names than the alleged victims in the case, possibly an oversight from Denver Health. I've explained to Mr. Klauck that having the wrong names on the SBI form doesn't necessarily mean that they can't prove the second degree assault allegations. That would probably be something that would be fixed pre-trial with endorsement of the medical professional. I've met with Mr. Klauck 4 times during the pendency of the case. I'm realize that he has interest in getting out of custody and expediting this matter, and I've tried to take that seriously and, step my foot on the gas for Mr. Clark here in negotiating the case and kind of trying to move things along. There is a misdemeanor offer here. It's a misdemeanor probation offer. That's.
I think we don't need to get into, that seems a little outside.
Okay.
Anything further on what he's asserting on the conflict?
Your Honor, there have been issues with the jail. I know I spoke to Mr. Clark's mother, who called before court on Monday. I tried to see Mr. Clark before Monday. I went to the jail, but by the time I went to the jail, they had transported him here. There's been transportation issues with Mr. Clark. So it's been hard to see him before court on several occasions, but I met with him 4 or 5 times to discuss his concerns and to discuss the case.
Okay. All right, Mr. Clark, as I indicated, in order to appoint yet another counsel, I have to make a conflict finding. I've heard what you've said. Just try and address as best I can the asserted conflict issues. 18 U.S.C. 1918 is a federal statute involving disloyalty and asserting the right to strike against the government. It's really not applicable here in any way and would not qualify as a legal or ethical conflict. As to issues regarding whether or not Miranda rights were violated, whether or not there are discrepancies in the discovery, and whether the case is provable, those are not conflict issues. Those are issues that are subject potentially to litigation. I haven't read your discovery. I don't know whether there is a Miranda violation or not. If there are weaknesses in the people's case because of documents, those are trial and motions hearings issues. But those don't rise to the level of a conflict. That's what litigation is for and what it's about. As to your assertion that there's a conflict because Mr. Levine has not done enough from your perspective to address what is potentially some civil rights or First Amendment issues that you're experiencing at the jail, Mr. Levine is appointed to represent you on the criminal matter. Pursuing civil rights lawsuits, he would not be appointed on those. Those are not within the purview of his appointment. It sounds like he's made some steps to try and address them, but and that's great, but that's not within the purview of his appointment. And so to the extent that he's not doing what you want him to do on that again would not rise to the level of any sort of conflict, legal or ethical, that would warrant appointment of alternate defense counsel. So your request for alternate counsel to be appointed is denied. With that, you have some options. One is you can proceed with appointed counsel as appointed, or you can request to proceed pro se. As I indicated previously, if you want to proceed pro se, I need to do what's called an arguello advisement. I would not allow counsel to withdraw. You can't just fire counsel when you have court-appointed counsel unless I can make a finding that you have the ability and that you are knowingly, voluntarily, and intelligently waiving your right to court-appointed counsel. What would you like to do between those two choices?
I'll stick to the word of God and go pro se, Your Honor.
Okay, I'm going to go through what's called an arguello advisement with you. Arguello is just a case that talks about what types of advisements and findings I would need to make for you to proceed pro se.
I have a copy for Mr. Clark if there were no changes.
I haven't looked at it, so why don't you, I'm going to have you follow along, sir, because you're going to have to initial these and understanding. Mr. Wharton's going to give you an advisement of your right to counsel. Okay, you have that written advisement in front of you?
Yes, Your Honor.
All right. It's entitled Advisement of Right to Counsel. To the defendant, Anthony D. Clark, that's you. Before accepting your decision to waive representation by counsel and letting you proceed pro se, the court advises you that the effect and consequences of your decisions are as follows. 1, a criminally accused enjoys the constitutional right to self-representation through the United States and Colorado constitutions. The right to self-representation is personal to you and may not be abridged by compelling you to accept a lawyer when you desire to represent yourself, citing People versus Romero. Do you acknowledge that understanding?
Yes, ma'am, Your Honor.
Okay, do you have a pen?
I do not, Your
I'm
Honor.
going to ask you to put your initials there. Sir, do you understand that you have the right to be represented by counsel throughout these proceedings?
Yes, ma'am, Your Honor.
Please put your initials. Do you understand that if you cannot afford an attorney, one will be provided to you free of charge? And indeed, that's court-appointed counsel Scott Reich's firm and Mr. Levine in this circumstance.
Yes, ma'am, Your Honor.
Okay, initials there, please. Do you understand I will appoint counsel, or rather continue appointed counsel if you want an attorney to represent you?
Yes, ma'am, Your Honor.
Okay, initials there for me. Regarding the relevant charges, do you understand as follows that the charges against you are count 1, assault in the second degree, a class 4 felony?
Yes, ma'am, Your Honor.
That's an F4 felony. It carries a presumptive Department of Correction sentence between 5 and 16 years. That's a non-mandatory Department of Correction sentence. Do you understand that?
Yes, ma'am, Your Honor.
Initials there, please. I don't think it can be as little as 1 year.
I actually wasn't sure at that time with the extraordinary because it is a different sentencing structure than your standard F4.
It's
So
a 5 to 16, non-mandatory.
Cor-
5's the minimum.
correct.
I
Okay.
can't find mitigation, right?
I guess not. No.
Okay. Mr. Clark, I'm gonna cross out as little as 1 year. The sentence on this matter is 5 to 16 years. If you are probation eligible, probation may be an option. I'm gonna cross out the next paragraph. It's not applicable. It is followed by 3 years of mandatory parole. Do you understand that?
Yes, ma'am, Your Honor.
And there's possible fine between $2,000 and $500,000. The count 2 is assault in the third degree. That's a class 1 misdemeanor. That carries a jail sentence from 0 to 364 days and a fine of up to $1,000. Do you understand those two?
Yes, ma'am, Your Honor.
If you could put your initials there and there. How far have you gone in school?
Second semester of junior college, Your Honor.
Did you graduate high school?
No, ma'am, Your Honor. I got my GED.
How far did you go in high school?
Ninth grade, Your Honor.
Okay, 9th grade, GED, and then you did some secondary.
Schooling and junior college. Yes, ma'am, Your Honor.
How far did you do in junior college?
A year, Your Honor.
Sorry.
A year?
Okay. So 9th grade, GED, and 1 year of junior college.
Yes, ma'am, Your Honor.
Are you under the influence of any drugs, medications, or alcohol?
No, ma'am, Your Honor.
Is there any reason why you may not understand these proceedings?
No, ma'am, Your Honor.
Check no there. Do you understand that I will allow you to consult with the public defender before you make a decision? Well, I'll allow you to consult with counsel, but there is a conflict with the public defender. But before you make the decision to waive your right to counsel, you may consult with your counsel now. Do you understand that?
Based upon the motion that he has submitted to the court, he is no longer my counsel, Your Honor.
No, he is your counsel unless and until I grant the motion.
Not at all. I don't want to talk with you for nothing.
Do you understand that I'll give you time to consult with your counsel before?
Yes, ma'am,
you
Your
make
Honor.
this-
I
Let me
apologize.
finish. Let me finish. Do you understand that I'll give you time to consult with your counsel before you make this decision?
Yes, ma'am, Your Honor. I apologize.
Please check yes. Do you understand that criminal law is very complicated and that an attorney trained in criminal law could be of great help in preparing and presenting your defense?
Yes, ma'am, Your Honor.
Okay, please put yes there. Do you understand that you have the right to represent yourself, but by doing so, you take a great risk of not properly presenting your defense?
Yes, ma'am, Your Honor.
Please put yes there. Do you understand that you have the right to remain silent and anything you say can be used against you in court?
Yes, ma'am, Your Honor.
Okay, please put yes. Do you understand that you have the right to confront the witnesses against you and to cross-examine them?
Yes, ma'am, Your Honor.
Okay, please put yes. Do you understand that you have the right to have witnesses you choose to call compelled to appear and testify on your behalf?
Yes, ma'am, Your Honor.
Okay. Do you understand that the court may, but is not required to, appoint advisory counsel to assist you in the preparation of your case?
Yes, ma'am, Your Honor.
Knowing your right to the assistance of counsel and knowing the disadvantages of proceeding without the assistance of counsel, is it still your desire to represent yourself in these proceedings?
Yes, ma'am, Your Honor.
Okay, please check yes. Is this decision to represent yourself made of your own free will?
Yes, ma'am, Your Honor.
Okay, please check yes. Is this what you want to do?
Yes, ma'am, Your Honor.
Do you understand that if you waive the right to counsel, you will still be bound by all the normal rules of procedure and evidence, and that counsel would be familiar with these rules?
Yes, ma'am, Your Honor.
Please put yes. Do you understand that there are possible defenses to these charges which counsel might be aware of, and if these defenses are not raised at trial, they may be lost permanently?
Yes, ma'am, Your Honor.
Do you understand that in addition to defenses, you have many rights that, if not timely asserted, may be lost permanently, and that if errors occur and are not timely objected to or otherwise timely raised by you, these errors may be lost permanently?
Yes, ma'am, Your Honor.
You are further advised that the advantage of representation by counsel is counsel's familiarity with the following procedures: pretrial motions, including motions to suppress, challenges to the bill of information or the indictment, protecting your right to a speedy trial, selecting a jury, cross-examining all witnesses against you, challenging the admissibility of any evidence presented against you, calling witnesses and presenting evidence on your behalf, arguing the facts and evidence to the jury in your behalf, arguing the law and evidence to the judge, and in the event of a conviction, filing, presenting, and arguing motions for a new trial and/or arrest of judgment. In the event of a conviction, arguing the circumstances, facts, and law on the presentation of witnesses and mitigation of that sentence. Do you understand that an attorney who's barred and familiar with criminal law will be better prepared to do all of those things?
Yes, ma'am, Your Honor.
You're further advised that if and when errors occur during the trial, the right to appeal based on those errors is permanently lost by you unless you object to those errors at the appropriate time.
Yes, ma'am, Your Honor.
Do you understand that you'll be precluded from asserting the ineffective assistance of counsel concerning all proceedings in which you choose to represent yourself?
Yes, ma'am, Your Honor.
Have there been any threats or promises that have induced or caused you to waive your right to counsel?
No, ma'am, Your Honor.
And then I'm going to have you sign, sir, and date at the bottom. Before I read this to you, I'm going to just let you know, sir, I would highly encourage you not to represent yourself. Do you have any training in criminal law?
No, ma'am, Your Honor. Just knowledge of the Constitution, and I know that my rights are being violated in this case, Your Honor.
Okay. Sir, as I've sort of given you a preview, I don't know that you have knowledge of criminal law or the Constitution, because the arguments you made to me today would not hold up. And probably if you're going to make similar arguments going forward in motions and trial, those are not likely to have any merit.
Well, then I would believe that this court is also in violation of due process of my constitutional rights, Your Honor.
Okay. Having given you that advisement, do you acknowledge a full understanding of the rights you have and the rights that you're giving up? That was a question. Are you thinking? Okay. Mr. Wharton, will you print another copy? Because I'm going to take the one he signed.
It was not signed, Your Honor, nor dated yet.
Okay, I'm just going to ask a printed version because when you sign and date it, I'm going to take that and that'll be part of the court file.
Yes, ma'am, we'll be sitting here for a while then, Your Honor.
Do you need time to think about it?
No, ma'am, Your Honor, I just refuse to continue with this proceedings based upon you clearly told me that the motion in regards to my rights doesn't matter in the case. So, you know what, we'll just see how it goes, Your Honor. We'll see how it goes.
If you're unwilling to answer that question or sign the document, I'm going to make a finding that I cannot find that you're knowingly, voluntarily, and intelligently waiving your right to court-appointed counsel. I'm going to deny your request to go pro se. You'll continue with counsel as appointed